Hey everybody, it is Tracy, and I am talking to my friend Ron Berglund. And Ron's a probate attorney. Ron, how long have we known each other?
Probably 20 years, 18 from when you started working with me at the med spa. Yeah, long time.
Long time. Yeah. And Ron is a probate attorney. And I was just talking to Ron because, he was like, well, what do you want to talk about? And I said, after I've worked in the legal field for over 40 years, and something that I think you think seems like it's easy to understand isn't, like I wanted to talk about like kind of um like beginning stuff too, like what happens if you die without a will, because I think a lot of people just think it automatically goes to like your kin or your heirs, which is not the case, right?
Right.
So
Not
why don't
necessarily.
you tell us a little bit, like, about yourself, and maybe talk about, because I know we were just saying how you talk to people all the time,
Yeah.
that what they, questions they have.
Now, for the last probably 7+ years of my career, my legal career, which has been a long time, I've been
Yep.
focusing on these areas: estate planning, probate.
Mm-hmm.
The saying is, if you don't have an estate plan, I'll handle the probate. They
Yeah.
kind of. And then there's always related real estate. That's half the reason you're doing all this, is because of the real estate. And I'd have a pretty extensive background in basic real estate. And
Mm-hmm.
then I work with small business owners and that sort of thing. But I typically, I get a lot of business from Google My Business. People will type into Google. They find out from a realtor, hey, my dad had a house in Bloomington, Minnesota, a suburb of Minneapolis. And the realtor is like, the kids don't know this stuff. Nobody, the realtor is like, oh no, your dad owned that home in his own name. You'll never be able to do anything with it until you bring a probate for your father's estate.
Mm-hmm.
So then they Google in Bloomington, Minnesota probate attorney, and up pops Berglund Law Office. And then
Mm-hmm.
they give me a call. And so for probate, they don't understand it at all. They're like, the realtor told me, or I read on the internet that I have to bring a probate, because if someone passes away owning real estate in Minnesota, and it's like this in most states, there's no little, some special thing up in the sky that will transfer it to their kids. It doesn't happen that way.
Mm-mm.
There has to be a probate court that, first of all, and there can be either with a will or without a will. Either one works. They just have different ramifications. But you have to go through this probate, and it's an investment like everything else. It can drag on depending, but you want to avoid it if you can. And that's what I do with estate planning, is I show people how to avoid probate. But if they didn't come and see me, and so many of them didn't do anything, the only way to get that house squared away is to go through probate. So that's the most common question I get when they call me for estate planning, as opposed to probate, is they say, well, hey, hi, I hear you're an attorney in Minnesota. Yes, I am. And they might be in Florida, and I'll say, nope, it's state by state. So you've got to contact a Florida attorney, that sort of
Mm-hmm.
thing. But if
Mm-hmm.
they live in Minnesota, at least most of the time, they can do a Minnesota estate plan. And they can do all kinds of great things to avoid probate, to avoid guardianships and conservatorships. It's wonderful. But
Well, can
everybody,
you can you explain, Ron? Because probate, you think probate is like estate planning, but it's estate planning is when you plan before you'd have to go to probate, right? Because probate is where
exactly,
you go
is
there
you
when
don't have a plan.
you
Yep.
have a problem, right?
Yeah. Well, if they end up and nobody did a plan, the only way to get that house, that if dad owned it in his own name, or if mom and dad owned it and they were in an airplane crash, you've got to have some mechanism to transfer title to the kids or their church or whoever, and that's probate. There's
So
no
and what
shortcuts. You've got
so
to do it.
if you die without a will, it's called intestate, right?
Yes.
And so where does it go? Like if you die without a will and nothing is named, what happens?
Well, yeah, okay, that's a good place to start. So if you start with an asset, let's say it's a house, and let's
Mhm.
say dad lived in Bloomington, and let's say mom died 10 years ago, so she's kind of out of the picture now. So how do you get the house legally transferred out of dad's name into, let's say he's got 2 kids, so that the kids can sell the house? That's what
Mm-hmm.
they usually want to do. Sometimes families like to move into the parents' house, but
Mm-hmm.
it depends. So there is, in Minnesota, it's a cardinal rule that real estate in a decedent's name only has to be probated. There's no trust, there's no transfer on death deed. It wasn't owned jointly with someone else. It's in the decedent's name. It's got to be probated. So that's number one. They have to hire a law firm, or they can try to slug it out themselves, but it takes Einstein these days to do it. There's so many technicalities and forms, and it's horrible. So then you're down the path of probate, and it's like a road that has 2 forks. You take one fork if, like Prince, no will. That's called intestate.
That's crazy for
And
how
it
much
goes
she
by
had.
statute. And I'll explain in a minute how, in many cases, it doesn't matter, but in many cases, it's insane what the statute makes happen. And that's just by going by the Minnesota State Statute of Intestate Succession. That's no will. Over here, you've got the pathway where there is a will. So what the probate does is, first of all, they have to find out if it's a legitimate Minnesota valid will. Has to be witnessed by 2 people, notarized, has to be in the proper format. A lot of wills, I came across one from a friend who passed away sadly out in Colorado. And his brother sent me some snapshots of the will, and it was all crossed out and crazy because my buddy was a little crazy. And he had signed as his own witness. So I told who's my buddy, also
Yeah.
said, I'm not a Colorado attorney, but I hooked him up with a Colorado attorney up in Aspen, because this all went down up in the ski areas. And I said, this guy is a Stanford graduate, Stanford Law. He'll probably be expensive, but he'll be good. And you got to bring that will in. I think he's going to tell you it's invalid, which from your perspective is great, because in each case it's different. But in this one, my buddy, his brother, is the last survivor of the family. There's no children, no grandchildren, no siblings, nothing. It's just him. So I said, the best thing would be is if they just say it's yours, because they will throw out the will. But first of all, and I've run into some, silver-haired realtors that should know better, but they don't, because in real estate school, they don't teach about probate. They have to pick it up through the seat of their pants. One old guy was almost arguing with me. He's like, well, this guy had a will and it was valid, and there was a notary and 2 witnesses, and, so he should just be able to transfer the house. And I said, no, where have you been for 40 years? That will is just a pile of papers until a probate court judge bangs the gavel and says, I deem this to be a valid Minnesota will. Then you're off to the races with a probate. Then the task is to implement the terms and conditions of the will. And if whoever is named in the will as the personal representative, that's the person who calls the shots.
Yeah.
And if there's nobody named or whatever, then they have a statutory, order of priority, who is the first one to be chosen. Let's say it's siblings now. Sometimes the siblings, and I've had families, I just had a farmer in the other day that had 15 siblings in Bloomington, Minnesota. I'm like, what? Because that was when they had a farm years ago. And the more kids you had, the more laborers, free labor.
Yeah. Yes.
Different world. But can you imagine talking about herding cats? Because I have trouble sometimes with just a brother and sister fighting. I can't imagine 15. But basically, if everybody's of equal footing to be named the PR and the will doesn't name a PR, or there's no will, then I try to get them to agree. And you can have co-personal representatives. That's okay. But if there's 5 or 6 kids, how do you do that? So that's a little bit of a tango that you have to do. But basically, the court then will say, okay, boom, then Mary and John are the personal representatives. And then you come to another fork in the road and you go, formal or informal probate? Not a big deal, but with a formal, your hearings are before a judge and it's a little more formal and there's accountings. With the informal, which the majority of mine, I like it because it's quick and easy. And
why would you do formal over informal?
Well, here's an example. And I've got one going right now where this law firm did a big project for dad, and then well into the project, it was almost done. It was a $40,000 incredible adverse. It was a complicated, quiet title action.
Uh-huh.
And the law firm was like telling my client, the kid, the son, you owe us a ton of money. We're filing a claim. So they'll file a claim in probate court. And when you're going to have a battle, you can foresee it and you're going to file a formal. So there'll be a,
Okay. Yeah.
but
Yeah.
if it's just a real simple one, like the majority of mine, thank goodness, you just do an informal, and usually they just go boom, 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 really cool. Because like if the two brothers can agree, let's say they want to be co-PRs, and all mom had was a house and
Mm-hmm.
maybe a couple bank accounts, it's like pretty much of a piece of cake. But you still have to go through about 25 steps.
Mm-hmm.
It has to be done perfectly. The
Well,
golden,
I know for me, I'm my mom's what do you call it? Attorney, what do you call that? Oh my
well,
gosh.
there's many instruments. I mean, while they're alive, they can
I
have
have her
powers.
power of attorney. I'm power of
So
attorney.
you are the
Okay.
attorney in
Yeah.
fact. Yeah.
So yeah, and the attorney in fact. And so I just took and for her healthcare directive too. And I know when I was looking, because I'm a notary,
Yeah.
and we were looking, it's hard sometimes to get two people to go notarize something. Everybody's
Yeah.
busy. And I looked it up, and I think in Minnesota it said I could sign. Well, I wasn't her power of attorney at the time. She was doing a will. I did a will up for her. And they said I could sign as a witness to her will. I did it.
You're not supposed to if you're a beneficiary, though. So
Yeah, and that's what but it looked it up, and I even asked somebody else. So those are the things too that I don't think that people know, like little nuances like
well,
that.
no,
Like
they don't. People don't even know the big picture, let alone the nuances.
right.
So the most common question I get when the people call about estate planning, they see I don't know, somehow they hear about, they might go do a Google search or whatever. The most common question I get, without a doubt, is, I've been reading articles and I've been hearing people, and I need a will. Are you single? You need a will.
Yeah.
Or I need to revise my will that was done, 10, 15 years ago.
Yeah.
And I say, well, let me stop you right there. And I said, somehow there's this misconception that wills help you avoid probate. And I go, au contraire, it's just the opposite. A will is a ticket to probate court. It requires probating. A probate court judge has to say, this is a valid will, and now we're going to accept it for probate, and we're going to appoint PRs, and we're going to follow through and close it out and get it done. But otherwise, it's just a pile of papers. And like I say, that old real estate guy, he's like, oh no, they could see that this guy was the beneficiary and blah, blah, blah. And I'm like, no, that's no good. You've got to really dig in and do it right and make
So
sure.
every person, I don't even, so get this straight. Every person that dies with a will that has assets, it goes to probate court because the judge has to say that it's a legal will. And then it moves forward with like the probate
Well,
itself, like establishing the estate.
you got to take one step back. Here's the cardinal rule number 2. Probate is only for assets that are in the decedent's name only.
Oh,
Let me give you 10 examples of things that are not in the decedent's name only. If the decedent had $1 million life insurance policy and appointed you as the beneficiary, non-probate. All you have to do is write a letter to the company and say, I'm the beneficiary, send me that $1 million. Number 1. Number 2, and this is what I coach people how to do to avoid probate. And I'm waiting for the day when someone says, I went to the bank to set up some new accounts because I moved here or whatever. And, I'm 70. And the banker said to me, you should set up a PODs for your children, payable on death. The guy's like, what's that? Well, you just simply fill out a sheet at the bank or the credit union. You say, I've done this with all my law firm accounts, all my personal accounts. My named person of the payable on death, it's a designee, is my son and my daughter. Here's their social security number. Make sure you get a copy. BMO Harris won't give you a copy. So the next time I'm in there, I've got to remember to take my smartphone and take a picture, because they're like, well, there it is on the monitor. It says your POD for these 7 accounts. Take a picture, give it to your kids. I'm flying to Vegas next week, if my plane crashes, they're incredible. You walk in there, you show them a certified copy of dad's death certificate and your driver's license, and boom, that day, in most cases, they wire the transfer of the money to the kid's account.
Wow.
Now, in Minnesota, there's two rules for probate. One is real estate in the decedent's name. The second rule is everything else, which is called personal property, stocks, bonds, bank accounts, you name it, IRAs, 401k, anything. The magic number is $75,000. Back when I was a young greenhorn attorney and didn't know anything, and I was handling my grandfather's estate, he passed away, almost hit 99.
Wow.
I go down to Hastings, and they made me bring a formal probate for one stinking bank account.
Okay.
Back then, I think they only had a $10,000, base limit. Now it's up to 75,000. But because my grandpa had like 20 grand in the bank, this mean old judge was like, no, formal. And I said, he's just got my dad as a son and his daughter in San Francisco. That's it. You're making me, I had to make 4 trips to Hastings to do this simple. Now, what you do now is, if they have personal property, because if you have real estate, it doesn't work. But if you have personal property only, and if you add everything up and it's less than 75 grand, and I've done this for a number of people, and it's kind of one of those things I can do just to be a good guy. This lady in my building, I'm in a senior independent living condo, and sometimes, old Dick passes away and his wife is like, what do I do? What do I do? And we didn't even own the condo, we're renting it. And I'm like, well, yours will be simple. If you run into a problem, yeah, I can't get the money out of the bank account because it was in his name. And I say, how much was it? She says, oh, about 10,000. Did he own anything else? Not really. So I do an affidavit for collection of small estate. If everything else is less than 75 grand, she signs it. I'm the surviving spouse, or a child could sign it. They bring it down there to the bank and they have a certified copy of death certificate. Boom, here's the money. It's like magic. So there are ways, but if they have $75,001, they're like, we need probate court letters.
So it's really important to have an estate plan, don't you think?
Well, let me start with this. When they ask me about a will, I tell them, a will is always a good idea as a backup plan. But I show people how the best will you can have is one that you don't use, because you figured out how to make everything non-probate. You go asset by asset. And some of these people, when they get into their 80s, they get stubborn. I had a couple come in late this summer, and they were just adamant that they each needed their own will. And of course, they're in Minnesota, so their name is Ole and Lena. And I make that up, but Ole had one kid from a prior marriage, and Lena had like 4 or 5. So Ole had his will all from 10 years ago. He's like, I want to update this and make sure it's still good. It was 10 years ago. One kid, she gets all my assets that are in my name only, bank accounts and all that. And then Lena says, well, here's my will. It's more complicated because I've got 5 children, but one died. So I want his children, my grandchildren, to get his share. So she had this all mapped out in a will. And I said, well, let me do you a big favor here and save the family about $8,000. You'd think that would get their attention. But I'd say, because first, in most cases, you're going to have to probate Ole's will to the tune of right around $4,000, costs, fees, publication, the whole 72 steps you have to go through. Then a few years later, you'll probate Lena's will. How would you like me to show you how to achieve the same objective right now without needing probates?
Because here's the thing too, I just want to say the estate takes the hit. They take the money out of that when it costs money.
Has to pay. Plus, this is instant instead of waiting.
Right.
3, 4. I've got one going on 4 years. It's still not closed.
Wow.
The lady was a retired school teacher. With her IRA, it was about 110,000. They're like, well, you've got options. You can invest in this and this, and we have a real estate option. Oh, that's where you make the money. So she did this real estate thing through the state of Minnesota, school teachers, retirement, whatever. And they did these deeds of trust out of a New Mexico outfit. 4 years later, I still haven't been able to close it down because, first of all, these deeds of trust didn't mature yet. So I'm like, I've got to do this probate. They're like, well, they're not, we can't cash it out. And then a year or two after that, the president of the company gets on the hook with the SEC. So it's under
Oh,
investigation. Now the
no.
trustee appointed. I'm like, is this going to get any crazier? And it's down to where there's only about 14,000 left. But it can happen with a probate. I mean, it can be,
Wow.
and the gal didn't listen to me. I said, make your sister, who's down in Iowa, your beneficiary on the IRA. And
Yeah.
her sister could wait it out instead of it being caught up in probate and costing, and I don't spend much time. It just, it's 10, 15 minutes. And now I have to send the probate court another letter saying, I'm really sorry, I can't close it. Here's copies of the emails from the trustees and all these people in their
Right.
home. And so it would have just gone to her sister, and her sister could just patiently wait it out.
So is that the difference? So estate planning, that doesn't mean like just a will. That's planning, like you said, like there's an account here. So what are we going to do with that account so that when
Yeah.
that happens, it goes directly to that person?
You go,
And here's the thing too, now with, so many people are remarried, like you were just talking about
oh,
Ole and Lena.
stepkids, yeah.
Like now what goes to my kids? What goes to his kids? Who, what, why, where,
So what I was trying to show Ole and Lena, and they got just, my dad used to call it hardening of the arteries. They got just rigid and they practically stormed out of my office. I was trying to show them that instead of using wills to give this modest amount of money to their children and a couple of grandchildren, all they'd have to do was go to their bank. And I showed them an example from one of the credit unions in town that did a beautiful job. And Lena could go in there and she could say, well, I've got these 5 children or 4 children, and then we're doing 3 grandchildren. And I know how much I have in my account. So what you do is you have the bank, and this is all free. The bank has to do it. They don't like to because it's extra work, but you say, well, here's a $20,000 certificate of deposit, a CD. I want you to put, Mary Jane's name on that one. Here's her social security number. And then I want a $20,000 one for Peter, and I put his name on it. And you don't even have to give the kids the CD, because if they're not good to you next Christmas, give it to somebody else. But
You're
it's
done.
And it doesn't need a will, and it doesn't need probate. It's like you make sure somebody trustworthy is there, and you'd say, well, Peter, we've got a CD with your name on it. Go to the bank, give them a copy of death certificate and your driver's license. It's yours. No probate, instantaneous. But Ole and Lena, for whatever reason, they just wanted to have a will. And
they're old school. Well, that's what we just knew. Like, I'm not, I worked in probate a teeny bit, and one kid was left out of a will. I do remember this. And he, there's a reason why people are left out of somebody's will, when they have like 5 kids. And he was trying to, what do you call it? Trying to say that he's owed some of that money.
They have this thing called a will. They can contest a will.
Contest, that was it.
As long as it specifically omits a kid, it's totally, they're free to do it. But here's an even better way. And I had somebody contact me this morning about this, and I said, well, just because you somehow think you were named in your great aunt's will, I said, that would only apply if she ended up dying with assets in her own name. If she had a good estate planning attorney, there would be nothing in her name. So she talked about a house. I said, she could have been set up with a transfer on death deed. What that means is it has to be recorded while she's alive. And so the house would automatically, upon her death, whoever was named as the grantee on my condo, it's my 2 kids. And I named them as joint tenants for a reason.
Yeah.
And my airplane next month, if I fly to Vegas and it crashes, I've given them instructions on here's all you have to do. It's 1/10 the cost of a probate. It's instantaneous. And you bring it in there and you say, well, here's a certified copy of Dad's death certificate. Here's an affidavit of survivorship that my brother and I are named as grantees on his TODD. So literally, you could sell my condo in a few weeks.
Wow.
Well, probate, this and that. It's free. But it has to be done and recorded while they're still alive. So this gal that was checking and thinking she had an entitlement because she was supposedly named in a will, I said that would only be if your great aunt died owning property in her own name. She could have done a TODD, a transfer on death deed, to her house to it would be, it's out of your jurisdiction then. I said all her other money and everything she could have set up with all her accounts payable on deaths or beneficiaries. So there's nothing to fight about. There's nothing
Right.
to probate. It's
Right.
all
Right.
automatic. Call those non-probate assets.
Well, and I didn't realize too. So I did a will and a living will like a
Yeah,
long
don't
time
mix
ago.
those two up.
Nope.
There's no commonality. People call it a living will, but it's a misnomer.
Oh, it is. It
Healthcare
is. Yeah.
directive.
That has to do with medical stuff, you
Yeah, it's
know.
technically it's a healthcare directive, but
It
people
is.
get
It's a
all mixed up when you start talking about a living will. They're like, "Is that a will?" I'm like, "No, it's not a will at all, but just some goofball gave it that name."
and it's
They,
funny because, I think because I've been in the legal field so long, you kind of throw stuff out like 'cause assuming everybody knows what the difference is, you know.
oh no, and I get
But
some really sophisticated businessmen. They're a little embarrassed. They come in for a consultation and they're like, because they're really successful businessmen, but they don't teach us this estate planning and probate stuff anywhere unless you go to law school or
right.
paralegal. Even
Yeah.
those guys, until they get out and practice, don't know squat. So a guy's like, well, what's the difference between a will and a trust? And
Yeah.
there's a number of attorneys around that will sell a revocable trust or a living trust to a little old lady who absolutely didn't need it.
Right.
And sometimes they come up with this cockamamie excuses why. And I'll be like, no, that's a snowball's, maybe
Yeah.
if she's got 8 kids and they're going to fight, you might set her up with a revocable trust. But generally, I will only pitch that to a client if they have multiple real estate where it makes sense, like a
Right.
house in the Twin Cities, a cabin up north, and a condo in Florida. Yeah, let's talk a revocable trust because the
Right.
trust will allow you to avoid probate in all 3 jurisdictions. And
Well,
everything
and that's like
trans
what I want to talk about, like, because I don't even know what an irrevocable trust
well,
is,
be real careful there because there's revocable, which means you can revoke it if you
right?
it. And then
Yep.
a whole different thing is an irrevocable trust. That's carved in stone. You can't, there's no strings attached. And you do them for different reasons. But
Right.
people get so mixed up throwing this terminology.
Right. Well, and I know, like I said, so when I did my will, um, I didn't realize because Jesse was only like 12 at the time or something like that,
Mhm.
10. And, thinking, oh, I can just, well, we have a 10-minute warning, we have 10 minutes. But so
Okay.
just thinking that I could just put her, like, because I owned my house at the time and stuff. But I didn't realize that if they're underage, you have to leave it to somebody who trusts it to them because they aren't adults.
Trustee. Yep.
Yeah.
You do have to do some maneuvering because people under the age of 18 cannot own property, real
Yeah.
or personal. So
Yeah.
you have to either set up a special testamentary trust
Yep.
or you can do a revocable trust. And you can't even name them as the grantees on a TODD unless they're 18 years old. So you
What's
have
a
to really
TODD?
transfer on death deed.
Okay.
So that's the most common thing I do. I say, well, yeah, you want a will, and I'm happy to give you one, but I'm going to teach you that it's like a backup plan because
Right.
let's take your house first.
Right.
Now, if it's a husband and wife, it's beautiful. It's the best of both worlds because
Right.
if Oldie and Lena do a TODD and record it, if Oldie dies first, Lena can keep living there. And my kid's other grandma, she lived 35 years past her husband.
Yeah.
And she can keep living there as long as she wants. Then when she goes to sell it, it's the best of worlds, both worlds, because she doesn't have to revoke it or do anything. It's just a probate avoidance document. And
Right.
the deed, when they sell the place, will bury it and you don't have to do anything. It just goes away. But if you want to change it, like let's say you do a grantee to 2 kids and one of them gets killed in a car accident, you can actually change your TODD and take that person off, for a few $100. So it's a great vehicle.
So if you had left it to them and one of them dies, the beneficiaries, does it go to their heirs?
Well, it depends on how you draft it. And here's how I draft them usually. I say the grantee, I just did one the other day. I said it's Peter Peterson if he survives me. And if Peter
Right.
Peterson doesn't survive me, it's Joe Peterson.
Oh, right. So
So,
it goes in succession.
and if
Yeah.
by any chance they both have an accident or something, you just do a new one. It's not a big thing. It's quick
Right.
and easy. So they don't
Right.
have. Now, the beauty of doing the revocable or living trust is that it's all built in there. And it's a lot more of an expensive, cumbersome,
Right.
pain in the rear document. But it's got every contingency covered. Like, oh, if those two grandchildren die, then it'll all go to the others. You have you cover. It's like playing chess with Bobby Fischer. You gotta, be 2 moves ahead and be
right.
And I say to people when I'm doing the consult, I say, I don't want to spook you but it's creepy stuff, but I do have to talk about because we're planning eventually. We are all going to, and then even something we haven't had time to talk about, but incapacity is just as big of a deal because all of us, as we move down the path, I'm at the age where my classmates, I'm starting to see some people are, they're still here. They're like either mentally, physically. And as we get older, as you move up into your 70s and 80s and then beyond, mental capacity is a judgment call. It's got to be a licensed Minnesota physician who says, in my opinion, Ole no longer has the ability to make sound financial and healthcare decisions. And then he's appropriate, that the healthcare directive kicks in, that they might force, if he doesn't have estate plan documents, they might force him into guardianship and or conservatorship.
And that's because I have a healthcare directive for my mom that I can make decisions for her if she's incapacitated. Plus, I'm power of attorney.
Even an 18-year-old kid on the football team needs one. Mom thinks if he gets smashed on the football field, mom can say, doctor, he's brain dead, pull the plug. Like, nope. They have to appoint an emergency guardian.
Oh, wow.
Mom didn't have the kid. Because once he turns 18, mom can't tell the doctor what to do. He's an adult. And nobody stuff.
Well, we've gotten even into more that even I want to know about. So I'd love to keep having you on to discuss more, because that's why I wanted to do the Zoom, because then people come up with these questions, and then just to talk more about it. And it's just so good. Like I said, I've worked in the legal field, but people don't understand there's all different types of legal fields. You don't know all of them.
Specialty areas. So as you think of things, jot down notes. And if you get some comments from people.
For sure.
We'll do chapter 2 of this, and we can cover some. One thing we haven't talked about that really makes people's heads spin is, how could I not have the nursing home take my house when I get to that point?
Well, believe me, that's what I'm dealing with right now, because, my mom's 94 and she doesn't have a home. I actually just filed a financial elderly abuse claim against my sister this weekend. So, but I mean, it all would have been avoidable, like you said, had things just been just change stuff, So,
and even there's the laws of Minnesota medical assistance are really crazy, and nobody understands it. And in some cases they're just unreasonable, but they are what they are. So you have to learn how to pussyfoot around them. And the cardinal principle there is they have what's called a 5-year look back rule. So if you deed your house
transferred or anything, right? They're going to look, it's like bankruptcy.
If you deed it to your kids now, and you survive 5 years before you apply for medical assistance, and they ask you that question, you say 0, because I did it more than 5 years ago. If you're alive, the kids don't get your stepped up basis. So they might have a huge capital gain to pay when they go to sell it. So it's incredibly complicated. Nobody understands. So
I'm excited actually to talk
to a second we call this like a podcast or
an interview, I don't know, a Q&A, but these are fun. And I mean, I'm learning so much. And so, thanks for taking the time first.
No, it's fun. So
do this.
Let's do a second one. You let me know when and see how this goes and give me some feedback.
This has been great, Ron. It goes by fast,
Where are you living now?
Well, I'm in Florida right now.
Jeez. Okay, well, we'll have to talk,
I'm in the van. I live in a van down by the river.
Down by the river. Well, hey, we'll have to do that, because I get some Facebook things, but we haven't really talked for a long time.
No, we haven't. So, okay, well, I'll reach out to you and then we'll plan another one, okay?
Sounds great. All right, you have a great night, Tracy.
Thanks,
Take care.
Ron.
All right, see you soon. Bye-bye.